Hello, listeners. This is Mubilu Musoke with another conversation on democratization of Africa, the case of Uganda in comparative perspective. Today, we are continuing where we left off last time. We started new conversations about the history, the origin, the evolution and meaning of what I call the logical structure of human rights jurisprudence. The key words are logical structure. What do we mean by logical structure of human rights jurisprudence? The logical structure of consists of the institutional framework together with the philosophical premises on which constitutional decisions by the courts are founded. The institutional framework consists of principles of separation of powers and the supremacy of the Constitution, which is the central pillar on which this system, the logical structure, is built, and the sovereignty of the people, that's the power of the people. Together, these principles form the system of checks and balances which make a democratic system function to protect human rights. Democratization is therefore, in essence, about the creation of this framework and making it functionally effective. Those who have followed my conversations will be familiar with a phrase, political philosophy, which I have invoked in many contexts. I have, for example, consistently pointed out that political parties in Uganda are weak, dysfunctional, and sometimes lack identity because they do not have a political philosophy. Political philosophy is also equally important in the judicial process. A crucial phase in the democratization of Africa is going to be dominated by the judiciary. In order to perform their judicial function of democratizing Africa, for example, invoking the supremacy of the Constitution in order to declare the laws that are inconsistent with the Constitution or the Bill of Rights void, the courts must possess some form of political philosophy to guide them in order to protect liberty and political freedom in general. And the central pillar in the democratic institutional framework is the supremacy of the Constitution. Without the supremacy of the Constitution, protection of human rights becomes impossible, practically impossible. We have a lot to learn from the history of the United States in this respect. Here I have to remind my listeners the philosophical foundation that created the American system. And I think I cited that case before, the case which was interpreted by the Chief Justice Marshall in 1802 to declare that the Constitution was the supreme law. There is no article in the U.S. Constitution that declares the Constitution of U.S. to be the supreme law. This was logically deduced from the structure of the principles of separation of powers. Therefore, today I'm going to look at briefly two schools of philosophy in the United States in order to illustrate my point. Before, in a few weeks, we will be discussing and analyzing the decisions of the Constitutional Court of Uganda and the Supreme Court of Uganda. And in doing so, we shall be looking at these decisions in search of what philosophy guides them and how do they interpret the Constitution. And is that interpretation valid and effective or not? Before we answer those questions, we should have a comparative look at the American system, where the court already has some philosophical underpinnings on which to base their constitutional decisions. So, a brief survey of the general jurisprudence leads us to a closer look at the judicial process as exemplified by the U.S. Supreme Court, which sets the standards for the application of human rights law in U.S. The opinions of the U.S. Supreme Court are good examples of both what realism, the school of philosophy called realism we discussed, and the judicial politics, and also the critical legal studies exposed as ideology, masquerading as objective legal doctrine. The conservative justices on the Supreme Court of the United States have used the two methods known as textualism and originalism in interpreting the U.S. Constitution, especially in reference to the provisions protecting human rights. American conservative jurisprudence is therefore a specific brand of legal doctrine built around the two versions of how to interpret the Constitution. It is important to examine the Supreme Court conservative jurisprudence of the United States because it has an impact on the enforcement of human rights and democratization of society and the legal process in general. So we look at textualism first. By textualism, the Supreme Court conservative wing argues that the best, if not the only way, to authentically interpret the Constitution of U.S. enacted in 1787 is to extract a pure meaning from the text of the Constitution as originally drafted. The reason to use this method is supposedly to discover and extract the meaning which the text of the Constitution conveys or was intended to convey by the people who enacted that provision. Textualism seems to be based on the assumption that the words in a constitutional text, as contrasted with any other legislation, have a clear, unambiguous meaning which remains fixed for all time, waiting to be discovered or extracted from the text by the judges. Apparently, the logical implication of the philosophy of textualism is that given the same text, different people at different times and places will extract exactly the same meaning from the same original text. The question is whether this is possible in view of the nature of society and how it changes. This argument assumes that only Americans
resisting the magical taste of silky smooth Dove chocolate is difficult, but choosing which one is even harder.
Would one expect the same result if a European, for example, or an African or an Asian judge read and interpreted the same text? Do space and time, you could call that experience, add to the content, thereby transforming the text being interpreted? These are questions which we should bear in mind when we engage in interpreting any text, be it the Constitution or the scriptures or even the cultural norms. There are several defects in the reasoning of this version of textualism, which we must point out. First, it is assumed that words have the same quality as numbers do. Both numbers and words are used to convey meaning. They therefore have some identical functions in language in specific contexts. Numbers and words are, however, very different concepts in language. The content of a number, which, whether it consists of one digit or 1,000 digits, remains the same whenever you refer to it, as long as those reading the same number do so from the same mathematical base. Unlike a number, however, a word by its nature can have multiple meanings. Words do not have a single base to determine their meanings. The multiplicity and of the meanings in a text increases with the number of words when combined as phrases, sentences, or paragraphs, or a group of sentences constituting a section. article of a legislation. The meaning of words may also be changed by a punctuation. Punctuation may add or subtract from the multiplicity of meanings in a particular text. This means that logically each phrase, sentence, and paragraph or section in the case of legislation can have multiple meanings depending on how the words are applied or used or even punctuated in a specific text. Textual meaning is therefore inevitably variable with the rules of grammar. The second problem textualism poses is to assume that it is actually possible to know precisely what the people who wrote the original text had in mind when they chose and used specific words, phrases, or sentences and their punctuation. It is difficult to understand precisely or retrieve at a later date the life experiences of authors of a text went through. It is therefore an illusion to believe that a person sitting in the U.S. Supreme Court over 200 years after the Constitution was enacted can actually visualize the actual life experience, the people who drafted the original text of the U.S. Constitution in 1787 had precisely in mind when they used specific words to compose the text being interpreted. This argument may sound very abstract or even irrelevant to what we are trying to do, but it is not. And you will find out that when we are interpreting specific decisions of the Uganda Constitutional Court and the Supreme Court. The problems raised above become even more complex when we put the relevant text in its original political context. Democratic politics, unlike a dictatorship, succeeds through compromise. Compromise entails accommodation of as many views and opinions, objectives, and intentions as possible within a specific group or community. This renders each legislative text susceptible to multiple interpretations. Vagueness in drafting is often deliberate and the result of democratic compromise. So here we are dealing with the politics and the human nature in interpreting any legal text. It would therefore be implausible that logic alone of the interpreter of the text can extract a single precise meaning from a specific legislative text drafted under such compromising political circumstances. Lastly, textualism is susceptible to suffer from what we call a time-space factor. Time, by its nature, never ceases to stream into the endless future. Duration of time by itself impacts on all its existential subjects. This means that the passage of time inevitably affects everything that exists at a specific time. The perception and meaning of the subject of time changes relatively with time. The most affected subject of time is actually society as a whole or collectively. Social change is the result of the lapse of time on society. When society changes, and it is inevitable that it will change, due to the lapse of time, that is, when society is reorganized by new norms, one assumes all its components, such as norms, standards, meanings, change accordingly, including the meaning of the legislative texts. Among the social elements that change with time in society is language. All texts are composed in language. The Bible and Shakespeare's works are good examples of how language inevitably changes and transforms over time, so as society changes. Therefore, to argue that one can forever extract exactly the same meaning from the same text is to be oblivious to or deny the reality of the impact of social change on all components of society, especially norms and standards of language, and its grammar, from which the meaning of words is inherently embedded. Take the word marriage as an example in the contemporary social and legal controversies. The conservatives would argue the word marriage means marriage between a man and a woman. That is the meaning the conservatives wanted to attach to the word, because they are not actually interpreting the word so much as they are giving it, assigning a meaning to it that is compatible with their beliefs or ideology. They are no longer talking about the meaning of the word marriage. They are talking about the institution of marriage. There is a clear difference between in the meaning of the phrase the institution of marriage as understood in 1787 and a text which simply uses the word marriage by itself. This argument brings us to the second method of interpreting the Constitution of U.S. by the conservatives. The second method the conservative justices of U.S. Supreme Court use to interpret the Constitution is known as originalism. Originalism, like a textualism, relies on going back in time to the drafting of the constitutional text in question. The only difference between textualism and originalism is the fact that originalism goes back not to the text, but to the state of mind of the people who drafted the text. The focus of the originalism is the intention of the people who drafted the legislation. In responding to originalism, we reiterate and apply all the arguments we made above in the discussing the defects of textualism. However, unlike textualism, which relies on extracting meaning from a dry legislative text, originalism seeks to decipher, comprehend, and then interpret the intention of the original legislator. Originalism is therefore not very original in its methodology. Discovering the intention of the legislator has been the classic method of interpreting legislation for centuries. Originalism, however, is invoked by the conservative justices for specific, apparently political purpose or motive. The assumption is that there was one intention expressed in the constitutional text, because the legislation can only have one intention expressed in a specific text of a constitutional provision. If the legislator had more than one intention, that intention would have been expressed in the text itself. General construction philosophy argues one of the objectives of the originalists is to restrict the constitutional provisions to a very narrow meaning, that is, one that is explicit in the text. For example, the word marriage today is used to include civil unions between couples of the same sex. The originalists would clearly exclude civil unions between the same-sex couples in interpreting the word marriage, because the concept of a civil union did not exist in 1787. This example, however, is good in exposing the political motives of the originalists. By tenaciously hanging on to the original meaning of the word marriage, even though society has changed as a result, the concept of marriage has mutated to acquire a broader meaning different from the original. What is important in this particular context is the fact that we are talking about human rights. If the originalist methodology was universally valid to restrict meanings of words to their original context or meaning, the phrase "all men are created equal," which was used in the Declaration of Independence, would not apply to African Americans, who at the time the original text was written were slaves who could be treated as chattel. It could also not apply to women for obvious reasons. The originalists are conservative and therefore opposed to marriage between couples of the same sex. The best way to prevent such marriages from being included under the protection of the Constitution is to argue that the original intention of the drafters of the Constitution could not have included marriage between homosexuals and lesbians under the equal protection of the Constitution. Such an argument would be futile because the protection of human rights is a universal crusade. There is no way one can deny people married under civil unions their human rights while you protect the rights of those married under the traditional norms. Moreover, once the homosexuals are acknowledged as human beings, their rights have to be recognized and protected by the changing normative context of the society itself. The argument, however, is a double-edged sword. The originalists cannot say that homosexuality did not exist at the time of the Constitution was drafted, since homosexuality is acknowledged to have existed at the time the Bible was written. It is therefore reasonable to assume that the original makers of the Constitution were aware of the existence of homosexuality. The only difference between 1787 and now is the fact that now the homosexuals have the courage to come out of the so-called closet due to changes in society and the social norms that govern society. Therefore, the only purpose of the originalist method of interpreting the Constitution is to allow them to resist their interpretation of the Constitution as and to deny the enjoyment of the human rights to those concerned by the non-traditional interpretation of marriage. This conclusion clearly demonstrates that there is politics or promoting personal group interests involved in the interpretation of the Constitution. The results and as a result, the proponents where the right to argue, they have a right to argue that legal doctrine is politically manipulable. This argument leads us to the real motives of the originalists. Whenever the originalists say, sense that a broad interpretation of the Constitution may cover a group they are opposed to, they load their weapon of originalism in order to shoot it down. To that extent, the conservatives are playing politics like everybody else, even though they prefer to pretend that they are above politics in their interpretation of the Constitution. Fortunately, the nature of the adjudication process very often betrays the motives of the originalists. It is not uncommon, for example, to find the so-called conservative justices on the opposite sides of the Supreme Court's decision. When two conservative originalists find themselves on different sides of the interpretation of the Constitution, the only explanation is proof that originalism is not a scientific legal method that consistently and objectively delivers correct results. Originalism is politics, like all adjudication of controversial issues for which there is no single answer. Originalism inevitably leads to denial and therefore violation of human rights of the minorities who differ from the rest of the members of society. The ideological aspect may be exposed when we compare the translation of the Bible from Hebrew into other languages. Why are there so many versions of the translation of the Bible from the same original text? Clearly, it means that words, unlike numbers, as we pointed out at the beginning, can be assigned different meanings by different people in different contexts. There is no such thing as a fixed original meaning of a clear intention of the author, especially in a legislative legislation that is democratic, a legislature that is democratic because of the nature of political compromises. There would not be so many versions of the Gospels, all of which are regarded as authentic. Moreover, when we read the Gospels in the New Testament of the Bible, it becomes clear that meaning is in the mind of the interpreter or the storyteller. For example, even though the authors of the Gospels were trying to convey the same story to the reader, each story is told in a different way by the same authors of the different Gospels. The authors of the four Gospels are not different from the witnesses testifying about specific event at a crime scene. Each witness tells the same story from their perspectives. The differences in the stories does not mean that the witnesses are telling lies or they are not telling the truth. Human nature being what it is, and having been shaped by different experiences, possessing different capacities of observation, the witnesses of an event are in fact expected to give different narratives. This narratives. Judges should not therefore hide behind ideology and the politics in order to sell to us an empty theory of originalism by which they claim to render a pure meaning of the original text. I'll stop here for a few minutes and then I'll come back and continue the conversation.
Kati abasajja batuwalula wadde batuwalula ku kifuba naye bwe tuliwalira tuli bakasuka batuwalula buwaluzi kati abasajja batuwalula wadde batuwalula ku kifuba naye bwe tuliwalira tuli bakasuka lino eggwanga lya Uganda ddene era ggwanga kkulu osanga ebyobugagga enkumu n'ebyobuwangwa makula okwokosa n'empisa ennungi n'obuntu bulamu n'okwaniriza abavudde ebule n'ebweya musanga ne kabaka wange nze kabaka wa Buganda ye Ssaabasajja ali omu yekka teri mulala n'obugagga nfofolo tulya bukunkomoka kyokka bitudde mu mikono ebiri obagambe esatu ejjabali mu kintu amasannyalaze gosasula gayotebwa bo banene ffe tusasulira nzikiza mulago teri ddagala bo bwe balwala bagenda bweru bweraba ebinnya mu nguudo emmotoka ezaabwe tezimanyina nfuufu Serumbe tewabulankanya ensimbi z'eggwanga obujulizi bubula batububula olwo ng'agula ebizimbe ng'agula ettaka nga sendaba nkussere kubanga batuwalula buwaluzi kati abasajja batuwalula wadde batuwalula ku kifuba naye bwe tuliwalira tuli bakasuka batuwalula buwaluzi kati abasajja batuwalula wadde batuwalula ku kifuba naye bwe tuliwalira tuli bakasuka ganamunswa mwali atudde ntende Ssaabasajja kabaka esijja kutiitira mundeke nyimbe kanyimbe okuyimba emmundu yange ye palamenti yange mazimo gano tyasemaka okuteseza mu nju ye n'ab'ekika kye okozesa sserunyogi gw'otuma kwatebwete mutwakuwaza nnyo ne tutuuka okwetunda tunoonye ekyokulya twasembeza natulunzi betwagemanga endwadde z'amaanyi kati batukuba kalifomu batuwalula twebasa kati abasajja bakugologoke wadde batuwalula ku kifuba naye bwe tuliwalira tuli bakasuka batuwalula buwaluzi kati abasajja batuwalula wadde batuwalula ku kifuba naye bwe tuli
Listeners, I'm back to continue with the conversation. Before I went to break, I was talking about the conservative philosophy in interpreting the Constitution. In concluding this part of the conversation, we want to clarify the close relationship between philosophy and ideology in legal doctrine. We opened this conversation with summaries of the schools of jurisprudence which have influenced legal reasoning during the last 2 centuries. We believe that philosophy is essential to an effective judicial process. Philosophy provides a vision for social and political action. Judges must believe in a fair process of dispensing justice. Such a belief must be guided by a political philosophy, not ideology. Giving rules meaning transforms the rules into social norms over time. A social norm binds the whole society, and because it embodies a general principle such as the requirement for due process of law or rule of law before anybody's right or property is taken away, due process of law or rule of law in Europe and other parts of the world is a general legal norm which stands at the center of the administration of justice in Anglo-American jurisprudence. The general norm of due process of law consists of several rules, such as the rule that prescribes that nobody should be punished without a hearing. A requirement for a hearing means that the accused must be given an opportunity to be informed of the charges against him or her and be allowed to put up a defense against the charges. Another rule related to due process of law is the presumption of innocence under the Anglo-American jurisprudence. Presumption of innocence means that prosecution has the burden to prove the charge beyond reasonable doubt. Another rule related to the general norm of due process of law is the right to a fair trial by the jury of one's peers or by an impartial determination of facts by a judge. Behind the general norm of due process of law and the rules that are applied to enforce the general norm, a general philosophy that requires the impartial administration of justice and the duty of the court to uphold justice without corruption. The administration of law would be fruitless if the end does not lead to justice. Here, history and experience are the best teachers. The administration of law can and in history is full of examples when justice was subverted by the failure, deliberate or misconceived, to administer the rule of law, due process without prejudice or discrimination, and even outright vindictiveness of some of the participants. What is going on in Kampala should be an eye-opener for those who are not familiar with these situations. Prejudice, discrimination and vindictiveness may have been the result of racism or sexism or pure hatred of individuals accused by those involved in his or prosecution and her trial. What is going on in Kampala is a good example, I should point out again. To the extent the pursuit of justice is guided by a rational philosophy, it positively contributes to the well-being of the society as a whole. The opposite is true when ideology and political and politics determine the results of the judicial process. However, besides philosophy is its older brother, which is ideology. An ideology is an ossified philosophy. Ideology is dogmatic by its nature. It is a philosophy that has lost its transparency and rationality. Philosophy, unlike ideology, is based on transparent reasoning about the means to a desirable social end. A desirable social end is one that is collectively embraced by the majority of the society. And so it is important to point out these issues, because when we begin interpreting, looking at the judicial decisions of the Constitutional Court and the Supreme Court in Uganda, we will soon discover that certain decisions are dictated either by ideology and because there is no political philosophy. And that is a very, very serious matter. However, a minority view may in due course become a majority view as social change transforms society. And this history has already taught us this. This was the case regarding the social status of women and African Americans in the U.S. It took social change through the women's movement and the civil rights movement to transform U.S. society to recognize equal rights for women and African Americans. Rigid ideological positions which had been entrenched in prejudicial beliefs had to be dissolved by social change before rights to equality by women and African Americans could be recognized. These beliefs were ideological rather than philosophical. The difference between ideology and philosophy are, however, very, very important. They are still to be found in judicial decisions, some of which were handed down by the Supreme Court of the United States. We regard racism to be an ideology because it is dogmatic and irrational. An ideology by its nature is dogmatic and it is rigged and beyond rational reasoning. Let us use the three decisions of the U.S. Supreme Court to illustrate the nature and impact of racism as an ideology. The three decisions also clearly illustrate the process of social change and how it changes the meanings of words as society is transformed. In the case of Dred Scott versus Stanford, the U.S. Supreme Court, I discussed this at the beginning of these conversations, if you can remember, the U.S. Supreme Court made it clear that African Americans were not intended to be covered within the meaning of the U.S. political community. The reasoning of the court was simple and clear. Since African Americans were brought to U.S. as slaves who were supposed to serve the white community, they could not have been included in the concept of the community because the people who enslaved them could not at the time be, at the time the Constitution was written, have intended them to be included in the term political community. The races were clearly different and were not intended to be equal or integrated for that matter, and therefore were not equal citizens of U.S. In fact, the African Americans, not being members of the original political community, did not have the rights and privileges enjoyed by the citizens of the United States at the time the Constitution was enacted. The ruling in Dred Scott versus Stanford, the case was based on explicit racism or racist ideology. There was no mincing of words in the decision of the Supreme Court written by Chief Justice Taney. The white people and black people belonged to different races and therefore communities which were not equal and according to the court could not be treated as equals, equal human beings under the U.S. Constitution. Historians that believe that the decision of the U.S. Supreme Court in Dred Scott versus Stanford case was one of the causes of the Civil War in 1861. The Civil War was one of the bitterest civil war ever fought in the world at that time. It produced large numbers of casualties and bitterness between the South, the Southerners, and the Northerners. The positive outcome, however, was the abolition of slavery in 1863, when and in 1965, when the 13th Amendment was enacted. And as a result, the transformation of the U.S. society as a whole took place. Between 1865 and 1890, U.S. underwent what they call reconstruction, both in the economy and in social relations. In the case of another case decided by the Supreme Court called Plessy versus Ferguson, the Supreme Court revisited the issue of race in the U.S. society. The case arose from the treatment of the African Americans in what the court described as places of public accommodation. The appellant in the case was a passenger in a train. He wanted to travel in the same coach as of the train as the white passengers. The operators of the train refused to accommodate him in the coach in which the white passengers traveled. He sued the operators of the train for violating his human rights by refusing to accommodate him in the coaches in which the white passengers were accommodated. In its ruling, the Supreme Court held that the colored passengers had no right to be accommodated in the same coaches as the white passengers under the U.S. Constitution. The two races, racial groups in the U.S., the court pointed out, were equal but had separate facilities and had to be treated separately. The ruling in Plessy Ferguson is known as the case which established the doctrine of separate but equal. The court, in other words, ruled that equality did not amount to or entitle the colored people or the African Americans in general to the treatment, the same treatment as the white citizens. The full implications of the decision of the Supreme Court was that segregation of races was allowed and legal under the Constitution of the United States. The ruling in Plessy versus Ferguson was obviously an endorsement of contemporary racism, which held the view that different races should be segregated and treated differently, even though they were all citizens of the United States. The ruling in Plessy Ferguson was clearly based on a racist doctrine which allowed citizens of the U.S. not only to be segregated, but also to be treated unequally through segregation. In 1954, another important decision was made by the U.S. Supreme Court in Brown versus the Board of Education. A black girl sued the Board of Education after she was denied admission into the school that was exclusively attended by white children. After reviewing the Supreme Court decision in Plessy versus Ferguson, the Supreme Court found that the facilities in the schools attended by white children were much better than those attended by African American children. The Supreme Court overturned Plessy Ferguson, deciding in 1896 on the ground that the doctrine of separate but equal amounted to racial discrimination. And in fact, the principle or doctrine of separate but equal violated equal rights of the African American children to equal treatment and protection under the Constitution. Separate but equal was illegal because it violated the principle of equality of all citizens. under the law. From that time, school desegregation was deemed illegal and unconstitutional and a violation of human rights to equal treatment of all U.S. citizens. The decision in Brown v. versus Board of Education was a democratizing legal ruling in U.S. It endorsed racial equality in U.S. legal doctrine for the first time. This brief summary of the U.S. Supreme Court rulings, stretching over a century, clearly illustrates the changing meaning of equality under the U.S. Constitution. It is sufficient to show that first, there is a direct causal relationship between social change and the content of constitutional legal doctrines. In the specific case of racial equality, before the Civil War and the abolition of slavery, there was no racial equality in U.S. society whatsoever. After the ruling of Plessy versus Ferguson, equality of races did not translate into equality of rights. 60 years after, in Brown versus Board of Education, repealed the doctrine of separate but equal. Equally relevant, the equality of rights of all citizens without any distinction. So the Brown v. Board of Education, in other words, meant that equality must be equality. If one studies the three doctrines alone, the doctrines of Dred Scott, Plessy Ferguson, and the Brown Board of Educations, if you study those alone, you miss a large portion of the meaning of the doctrine and the causal relationship between the ruling and its impact on society. This leads us to the subject of the next conversation, namely how legal doctrines and social change interact and transform each other. Legal doctrine, in other words, the conversation is about legal doctrine and human rights. The impact of a specific judicial decision on society cannot always be predicted. Such was the decision in the case of Dred Scott versus Stanford. In Dred Scott versus Stanford, the Supreme Court displayed its true colors on matters of race just before the Civil War. The court pronounced its deeply felt ideological beliefs about race in its judgment. Racist ideology was the basis of its decision, since there were no legislative guidelines on which to rationalize the decision. It is apparent that for the Supreme Court, the consequences of its decision were irrelevant In fact, from the legal reasoning of the Supreme Court, it is clear that the judges of the Supreme Court did not pay any attention to the injustice of discrimination and therefore violation of human rights of the African Americans. They depended on what the ideology at that time was. Faith and conviction were more important than ethical and scientific analysis or the circumstances that were incidental to the case. The court, however, clearly expressed what many citizens in the United States believed and were convinced was the natural order of things in society at that time. Ironically, the conviction with which the decision was made also generated its profound impact on society. The decision turned out to be a prelude to the Civil War that was to consume society's lives and political energy for almost 4 years. We have clearly pointed out that Dred Scott versus Stanford is viewed by historians as one of the primary causes of the Civil War. The conviction with which the court expressed its racial views left little room to avoid the political conflict that broke out after the decision was made by the Supreme Court. From a causal perspective, irrational ideology eventually clashes with reason to produce conflict that changes society. That sounds ironical, but it's true. It simply means that social change is inevitable. In this case, it was a civil war which, ironically, was destined to transform U.S. society for the better, from the cruelty of racism to equality of all citizens within the society. The extremity of ideology is inherent in the failure of the court to see reason and use rationality in the decision. The paradox here is obvious. It took a rigid, racist ideological decision to compel reason to respond to the irrational decision of the Supreme Court. The argument sounds like thanking the folly of the enemy for arousing the courage of the victim that eventually overthrows ideological tyranny in American constitutional doctrine. Legal doctrine has impact on society. The impact may be negative or positive. In this case, it was negative, but it provided the necessary ingredients for social change. Now, let us look at the nature and function of ideology. In order to understand what an ideology is, it is important to briefly mention the other social indices that cause or influence human behavior in society. The following discussion is a simplified version of a very complex social phenomenon whose real origin is unknown, but we suspect is rooted in the evolution of the neural structure of human beings. All these social theorists, Karl Marx, Emile Durkheim, Max Weber, whose theories of capital, labor, and culture, which we discussed at the beginning of these conversations, all these theories oversimplified the matter when they reduced phenomena we are talking about to ideology, the capital theory, collective conscience by Durkheim, or culture by Max Weber, respectively. Social behavior is activated by what we call the social indices in these conversations that reside in the human brain, apparently in the neurons of each individual human being. Social indices are the active elements that create social consciousness of all human beings in a specific society at a particular time. The word knowledge comes close to describing collectively what we call the social indices, but some of them may be biologically inherited in the form of instincts, which means that we are not always conscious of them or how they work. For our purposes, it is sufficient to say that each individual in a society is a carrier of the social indices he or she shares with the other members of society to a certain extent. These indices may vary from individual to individual and from group to group within the same society. There are two perspectives to look at in a social indices. We may look at them at the micro level, individual, or macro, group level. The content of the social indices varies widely depending on which level one looks at them. What is important here is the fact that social indices determine behavior of the individual members of society. We have classified the social indices into three categories for the convenience of studying them. These are the ethical indices, which consist of morality, culture, and religion. The scientific indices, which consist of acquired knowledge through education, such as mathematics, physics, economics, biology, chemistry, and so on. And the third category, with which we are concerned, is that of the abstract social indices. These are philosophy and ideology. Philosophy is an abstract subject which depends on logical reasoning. When a philosophy becomes dogmatic, it ceases to be transparent, rational means of reasoning about ideas and society. In that state, philosophy becomes a dogmatic ideology which prescribes one sterile formula for the solution of social problems. Ideology, therefore, is any form of dogmatic conviction that ceases to rely on reason to justify or explain a conviction a person or group of persons hold. Ideology, however, should be distinguished from conviction that is based on faith. Faith implies belief that is the result of a higher abstract authority, such as God or the creator of everything, Almighty. Ideology, in contrast to faith, is a conviction that is derived from any source, logical, abstract teaching, for example, or prejudice. Hence, we classify racism, tribalism, homophobia, extreme sexism, and so on, that practiced by the Taliban as ideology. Most ideologies originate from abstract logical premises. That is why philosophy is the most common origin of ideology. So from political philosophy, we get the dogmatic ideologies of communism, of capitalism, and also of even anarchism. The most important function of an ideology is to consolidate and unite people who share the conviction about any subject, such as how to organize society or treat specific types of people without reference to rational criteria. Apartheid in South Africa was an ideology. A judicial decision like Dred Scott versus Stanford was based on dogmatic social beliefs about race, very similar to apartheid. Now, legal doctrine and social change, this is important. Social change is inevitable. Some people don't think so because society doesn't change from week to week or from month to month. So societies change so gradually that most people don't notice that society is actually changing. And so this is a very complicated phenomenon. When we talk about social change being inevitable, it means no society can remain the same for forever or even for longer. And now with so much communication, the so-called social media, social change is much faster than it used to be 2 centuries ago. Therefore, the main explanation for this is that social ideas are constantly changing, both within a single individual, macro, micro, and in society as a whole, at macro level. Therefore, no society can remain static. It is organized and exists according to the existential laws of space, time, dimensions. Social change can be, and usually is, a two-way process. For example, the racial attitudes towards African Americans at the time of the declaration of U.S. independence in 1776 were very different from what they were on the eve of the Civil War in 1860. The U.S. Constitution enacted in 1787, for example, contained a provision allowing slavery to continue within the United States with a cutoff date of 1807. However, by 1800, the abolitionist movement had been organized in U.S. and was gaining momentum. Therefore, there was a sizable group of people in U.S. itself who did not believe in slavery and viewed it as a social evil. However, it is important to point out that opposition to an institution of slavery did not amount to not being a racist. I don't know whether I have put that point clear. It is difficult to explain. It is the opposition to the institution of slavery did not amount to not being a racist. There are two negatives in that sentence that may make it difficult to understand, but the simple meaning is that what we are trying to say here is that being opposed to slavery was not the same thing as not being a racist. There were many people in the U.S. who opposed slavery, but at the same time believed that the two races were not equal and therefore could not coexist, intermarry, or peacefully live together on the basis of equality. Among these was Thomas Jefferson, author of the Declaration of Independence, who apparently lived a double life. He is alleged to have fathered children from his female slave, Sally Hemings, with whom he took her to France. They stayed there for a long time. And she had several children. But of course, Jefferson would not acknowledge that he was the father. The DNA science has already now shown to us that the descendants of Sally Hemings had a genetic connection to Jefferson, the third president. In fact, some people were racist, but were opposed to slavery at the same time. This apparent contradiction is manifested in the establishment of the state of Liberia in West Africa in 1820s as a place where freed slaves from U.S. would be shipped to be permanently settled from U.S. Territory in order to avoid interracial society in U.S. The proposal to settle them, the slaves in the U.S. separately, was defeated actually. So they had to settle by creating a territory on the African continent, Liberia. It is apparent that those who believed in the separation of the races, a form of racism, had declined in number by the time of the Civil War. So the society is all the time is changing. The movement to resettle African Americans in in another place had disappeared by the time the Civil War took place. So society was changing. At that time, there was slavery was abolished, and there was no need to export the freed slaves back to Africa. So the fluctuation of these beliefs means that society in the U.S. was constantly changing, and the racial attitudes were in a fluid form and certainly undergoing profound transformation all the time. This is why in Dred Scott at Stanford, there were, dissenting judgments. Social attitudes in U.S. influenced the decision in Dred Scott, but on both sides. At the same time, the judgment in Dred Scott had a profound influence on society itself. For some people, it indicated their beliefs, that is, that the ideology of racism had to prevail for the time being. But the truth is that there were many who did not approve the decision of the Supreme Court or uphold the racist ideology it explicitly endorsed. I'm giving these details because I want to avoid give the impression that there was one unified belief in the United States. No, there were so many ranges from one extreme to another of beliefs of people on the different. And that's why we talk about social indices. Some people were Christians and they had their own reasons to oppose slavery. Others were neither Christian nor non-believers, but they had their reasons for that, to hold certain views. So, between 1865 and 1890, a period of stretching over one generation in which many young people had not experienced slavery firsthand, there must have been extensive social transformation within U.S. society because U.S. had just gone through a ravaging civil war, but racism in a large section of the society was still alive and well. This is the period, by the way, when the Ku Klux Klan was born, when some of the racist people, when they saw that the black people were free, they took the law into their own hands and lynched people and intimidated even others, so that they won't come out to testify as to who was doing all these horrible acts. So you can see, and the Ku Klux Klan continued to exist in the U.S. until they say that even when Reagan was elected, some elements of it did surface in some parts of the United States. So, social change is not a one-time kind of process. Now, what I want to really point out is that in spite of all this, whatever was going on, there was social change. This is important because we are talking about liberating South Africa, liberating Uganda. You are going to have to carry out a lot of social change among the people to change people's beliefs before you can democratize them. A lot of people are too scared of the state they are not ready to, I know that on this radio we do constantly call upon people to come out and express themselves, but they don't. That should tell you something. A lot of people still don't feel like even when they are given an opportunity, a free opportunity to come out and say what they think, they still fear to come out and say anything. And so our job in democratization is not going to be easy, I can assure you that. And when it is done, when the regime in Uganda falls, again, then we will have to deal with the courts, which are going to make the fundamental judicial decisions to transform the legal system and the society itself, just as the United States had to go through these decisions I've been quoting to you. It is not without a good reason for me to do that. But I want you to see the comparison that these changes, if they were difficult here in the United States, they are difficult in South Africa, they are going to be difficult in Uganda. So the decision in Plessy Ferguson clearly shows that the Supreme Court consisted of some hardcore racist judges since the Constitution had been amended after the Civil War, not only to abolish slavery, but also to guarantee the equal citizenship of African Americans. The decision in Plessy Ferguson, which pronounced the new doctrine of separate but equal, means that the judges who endorsed the majority decision still believed in racism, equality of citizenship guaranteed by the Constitution notwithstanding. In fact, it is important to point out that from a sociological perspective, the Supreme Court decision in Plessy versus Ferguson institutionalized racism in U.S. society as a war. Surprising as that conclusion may be to many of my listeners. The meaning of this paradox is that Plessy versus Ferguson had profound sociological consequences in U.S. society as a whole. After Plessy Ferguson in the 1890s, racial segregation in the U.S. was an officially lawful policy. The army, the schools, and places of public accommodation, such as hotels and public transport, were officially segregated on the basis of race in accordance with the decision of the Supreme Court in Plessy versus Ferguson. It was not until President Truman many years later, signed an executive order that the army was officially desegregated, and desegregating a federal institution subject to the authority of the commander-in-chief was, however, much easier than desegregating society as a whole, because it could not be achieved by issuing an executive order of the president. So, in 1954, in Brown versus Board of Education, the Supreme Court overruled the decision of Plessy Ferguson. Brown desegregated public schools. We have to remember that. 2 points have to be noted here. First, the desegregation of schools was limited to public schools under the control of the state. Therefore, society at large remained officially segregated, and therefore racism was still an active, practical ideology. Nevertheless, second, the decision in Brown versus Board of Education had far-reaching social consequences. A year after the decision was made, Rosa Parks opened a new chapter in race relations in U.S. 1955. She refused to conform to unequal racial treatment on public transportation. The year 1955, therefore, marks the beginning of a revolution in race relations in the U.S. Emboldened and backed up by the Supreme Court decision in Brown versus Board of Education, which outlawed racial segregation as official policy in public schools, the civil rights movement, whose fuse was ignited by a humble but courageous and determined seamstress, Rosa Parks, was mobilized in a national movement by Martin Luther King Jr. Few have connected this chain of events to the legal doctrine of Brown versus Board of Education, but we are convinced that there is a close causal connection between the doctrine of Brown versus Board of Education and the civil rights movement. The objective of the civil rights movement, which clearly gained legal legitimacy from Brown versus Board of Education, was desegregation, to desegregate the U.S. society through a non-violent movement. Martin Luther King Jr. organized his followers who demanded to be served meals in segregated restaurants, hotels, and other places of public accommodation. Racism was still entrenched in some parts of the society. King and his followers used the civil disobedience tactic that was inevitable in the struggle for civil rights movements, set out to accomplish that goal. Civil disobedience is a deliberate violation of the law, which is viewed to be unjust. It takes courage to do that, to violate the law deliberately, knowing that you will be arrested, you will be taken to court, and probably imprisoned. So that element is important. And we, in comparison to Uganda, are we ready for that eventuality? Or in comparison to South Africa, do we have a Mandela? The violators of the law in a civil disobedience are prepared for the legal consequences, just as Mandela was, arising from the violation of the law. Civil disobedience is a conscientious action which requires courage and determination. We are not going to democratize Uganda just by talking. We are going to do it by taking action and by learning from the experience in the United States and in South Africa. In spite of the Brown versus Brown decision, the laws which segregated the U.S. society on the basis of race were still valid because the Brown decision ruling was limited to public school desegregation. It was therefore not until U.S. Congress enacted the Civil Rights Act 1965 that racial discrimination based on race was officially made illegal. Equality of the races was finally recognized by legislation 30 years after the Civil War. We therefore see two distinctive effects from the decisions of Plessy Ferguson and Brown v. Board of Education. While Ferguson's doctrine of separate but equal institutionalized racism in U.S. society and government, the army, the schools, and places of public accommodation, Brown versus Board of Education opened the door to fight racism by desegregating society itself formally. In both cases, legal doctrines had profound social consequences. It is therefore important to understand the fact that legal doctrines have serious social consequences by themselves. These consequences cannot be studied through the analysis of the legal doctrines themselves. That is the reasoning and the holding of the cases of the judicial decision. They lie outside the legal doctrines themselves. We must look at the actual consequences of the doctrines on society as a whole, outside the province of jurisprudence, as they say. In the three cases we have briefly studied, the consequences of legal doctrines were mainly social and political. Separate but equal, sometimes translated into the denial of African Americans the right to vote. Where the right to vote was not denied, it was made difficult to exercise due to taxation and other factors such as ownership, a requirement to own a certain amount of property, especially in the South, which most poor African Americans did not have. Legal doctrines can also have economic, political, and cultural consequences. Therefore, it is not sufficient for us to simply study and criticize the content of legal doctrines as the critical legal studies does. We should also study the causal relationship between the legal doctrines and society as a whole. We should move from critique to causal explanation. To the extent the legal doctrines in Dred Scott, Stanford, Plessy versus Ferguson, and Brown versus Board of Education caused discrimination, they also caused quantifiable poverty to those who were discriminated against, mistreated, or even denied enjoyment of their human rights protected by the Constitution. Both realism and the critical legal studies tried to expose the ideologies on which judicial decisions are based. But it is not enough to criticize bad judicial decisions. we must move from critique to causal explanation, because while the legal analysis in law schools, classrooms may enlighten students and scholars, it does not educate the general population about the role of civil disobedience and the receipts or the protests that bring about the necessary social change which transform society by breaking down or dissolving the prejudices and ideologies that form the foundation for the oppression of a large section of society. Now, I'll stop here and now appeal to all my listeners. If you have enjoyed listening, I will come back next week and give you another conversation, which I believe will go much further from what we've discussed today. But what is important is what will be happening in the meantime. We are in a fundraising period, and we ask you to support us so that this message can reach more people on a satellite radio. It is important that the people be educated, that they understand what the problem is and how to deal with it. And we cannot do that without money. So, be generous. We ask you to contribute to the cause, and in your contribution, be generous and be determined so that we can move the movement from the diaspora to the concrete ground of the state of Uganda. So thank you for listening. I believe I'll stop here. I cannot start another part of the conversation because I don't have much time left. But I urge you to go to the FADU website and make any contribution you can afford. But in doing so, please be as generous as you can be. Thank you very much for listening, and I'll come back next week and continue this conversation. Next week it will be more interesting because I'm going to focus on African scholars and their critique of our constitutional doctrines. Thank you very much. Until then, you have a good time.